Hey everybody, Roger Thorpe, president of Thorpe Benefits here. I'm joined by a couple of industry experts, and we've wanted to arrange this legal conversation for quite some time now. I'll ask everyone to briefly introduce themselves in terms of why they're here and what they have to offer.
Yeah, my name is Jason Hubbell. I'm a consultant with Open Access, and we are specialists in pensions and retirement savings. We work with employers and advisors across Canada as a record keeper and also a fiduciary managing investments and retirement plans for group retirement solutions.
And I'm Roger Thorpe, just in case anyone doesn't know. I'm the president of Thorpe Benefits. We're a integrated benefits and wellness consultant, and we're hired most of the time through senior level HR and finance roles as an upgrade from traditional benefit management. So the legal side of benefits, that's what we're here to talk about today. Dante, I'm going to jump in and throw the first question, but maybe you could introduce yourself.
For those I haven't met, my name is Dante Manna. I am a partner at Stewart McKelvey Law Firm in Halifax. I do labor and employment law with a specialization in pension and benefits law. And I work with a lot of employers sort of across the country who have employees across the country and pension plan administrators and benefits plan administrators.
The question we do get a lot of the time is clients want to change their benefit plans. And many times it'll be something that might control costs in some way. So truly, we need to understand sort of what are the legal implications or abilities to just go ahead and change a plan design.
I want to make clear that these are aimed at private sector companies and they don't constitute legal advice.
Right?
Yes, employers can absolutely change benefits. They can even reduce existing benefits within the four corners of the law. It is important to understand if you're doing it in a legally compliant way, which I hope you are, that what the general risks are, what the types of risks are, and when to consult legal counsel if there is any concerns. So there are two types of legal limitations on an employer's ability to change an existing benefits plans. Those are statutory and contractual. So I'll cover those in order. The first type of legal limit is statutory. So every employer has to meet minimum labor standards or employment standards, which are prescribed by legislation and they vary by jurisdiction of employment. These are things like paid leave, such as vacation, holidays, in some jurisdictions, paid sick leave. The key is that an employer, if they want to reduce their paid leaves, they cannot reduce those statutory paid leaves to below the statutory minimums. Another statutory limit is from human rights legislation. This one's a little more complicated, but generally human rights legislation prohibits discrimination against employees on the basis of certain protected grounds such as age, race, gender, family status, and mental or physical disability. So when making changes to a benefits plan, the idea is that the changes or the resulting plan should not be discriminatory on one of those protected grounds. So for example, if an employer decided to end a parental leave salary top-up benefit for women, but not for men, because the claims for women they thought were too expensive, that could be seen as discriminatory because it creates an inequity on the basis of gender. The men would have access to that benefit, but the women wouldn't. So the best practice in terms of guarding against that risk is to ensure that any benefit reductions are evenly felt across the whole group of employees, regardless of the existence of a personal protected characteristic. With respect to pension benefits, every jurisdiction of employment also has a corresponding pension benefit standards legislation, which regulates the employer-sponsored pension plans in that jurisdiction, all except Prince Edward Island, which doesn't have one. That statute, though, is overseen by a regulator who in most jurisdictions is known as the superintendent. There are also specific requirements under the Income Tax Act, but all of this legislation together effectively limits the amendments and how amendments can be made to a pension benefits plan. So one common provision that's across all the pension plan legislations in all the jurisdictions is a prohibition on a reduction of benefits that have already accrued to a pension plan member. So the implication of that is that benefits reductions to pension plans, generally speaking, are only made from the date of amendment moving forward. Now, there are some exceptions to that, particularly for what are called shared risk pension plans, which you may have heard of, and those are set up in a very specific way, though. In that case, the pension plan documents actually do set out that full benefits are contingent on the plan being fully funded, but for the most part, you're just looking at from the date of amendment forward. So those are different kinds of statutory limits. There's also contractual limits, which I said I would talk about. And just to note, my comments on this point are concerning the common law, so they might not apply exactly the same way if you were in Quebec, which is a civil law jurisdiction. But under common law, if the impact of reduced benefit amounts to what would be considered a significant decrease in overall remuneration without the employee's consent to the reduction, there is a risk the employee would be considered to be constructively dismissed. And that's a term that means that they can quit their job, and then they would be entitled to damages from wrongful dismissal for the employer's breach of the employment agreement. So an extreme example of this risk would be, like, let's say an employee's annual income were structured as a non-discretionary bonus for half of it, and then salary for the other half. And then the employer just decided to end the bonus, thus cutting the employee's salary effectively in half. That would quite likely be considered a constructive dismissal. And then so the question is, well, if it's less than half, where is the dividing line? And there is always some sort of risk if there's a significant decrease in overall remuneration. So just to mitigate that risk, if there's an employer who wants to make changes to their benefit plans, one thing they can do is to ensure that their written employment agreements that they have with their employees would explicitly permit them to change, reduce, or terminate employment benefits from time to time. Doesn't constitute 100% protection, but it definitely helps. Another concept from the common law that I wanted to talk about besides constructive dismissal is what's called a vested benefit. And that's when a benefit has been earned by an individual, even though it may not have been paid. So benefits don't always vest right away. One example is stock options, which could be granted to an employee up front, but might vest over a period of 5 or 10 years, which is meant as an incentive for that employee to stay longer. But the point at which a benefit vests would normally be set out in the stock option grant in that scenario, or generally speaking, in the policy documents or the plan documents that set out the terms and conditions of the plan. Vesting of the benefit can also be addressed in an employment agreement. It can be addressed in a collective agreement. But the point is that the unilateral removal of a vested benefit is generally considered a breach of contract. And so the individual in whom the benefit is vested may seek recovery through the court or through another applicable process. So again, what we're talking about here is really focusing on a change. If you're reducing a benefit, changing that from the moment forward and not affecting anything that has vested in the past. So my last point I want to make is about unionized employees. So this isn't every employer out there, but if you have employees who are represented by a bargaining agent, there may be a risk for those employees when you're changing benefits and additional considerations. If you were to reduce benefits without the consent of the union, or even change them without the consent of the union, there's a risk you would be in breach of the collective agreement, which, as you would know, being a unionized employer would entitle the union to grieve and have those benefits reinstated. And the degree of risk really depends on the degree to which the benefit is incorporated into the collective agreement. So, for example, if the collective agreement explicitly states, that the employees get 4% employer matching RSP contributions, that is a collectively bargained benefit that would be protected against unilateral change by the employer. And that whole process, the grievance process, is protected by trade union or industrial relations legislation. So, really, you just go through a different process. So, the union could agree. If they don't agree, the employer may have to wait until the end of the current collective agreement, and then they would negotiate the benefit reduction through the collective bargaining process. So overall, in answer to your question at a high level, there's always a way for an employer to legally reduce benefits to save costs. An employer should, though, remain aware of those statutory and contractual limits, including the ones I've mentioned, to those changes, and contact legal counsel to discuss any potential concerns before moving forward.
That's great. I think my takeaway, Jason, would be as an advisor to a client right on the front line would be caution and to ideally make these changes well enough in advance that you can make your own internal filters for these changes, but then know, what this requires a legal opinion here. Let's be careful. So I think that's sort of the two-step sort of process to making a change and being careful with it.